The topic on which I would be discussing is sources of environmental law in India. Why the discussion on source is important. The sources would lay down the foundations, thereby casting an obligation to conserve, preserve, manage and regulate the environment in a way that could be done in a sustainable fashion. As far as the Indian situation is concerned, we could see that there are formal and informal sources, wherein formal sources refer to those which are legally recognized ones, and informal ones are referring to the efforts taken up by the communities, the non-governmental organizations and even the best efforts done by the public spirited individuals. And based on that premise, if we proceed, we could see that there are certain sources which are well evident in the Indian context. One is the Constitution of India adopted in 1950, the legislations which are enacted in accordance with the provisions of the Constitution, the decisions of the courts, particularly those of the High Court and the Supreme Court, and generally the international obligations taken up by India in pursuance of the obligations laid down in the treaties. Now, to begin with, therefore, we look at the Constitution of India in the first place. We could see that if we look at the Constituent Assembly debates, there were discussions centered around fisheries and forests particularly, or the issues like health and sanitation, discussed at length as to where these could be allocated. The Ministry of Agriculture had actually proposed for their inclusion in the concurrent list, because the ministry felt that the agricultural prosperity of India to a large extent would be decided by the way we use the forests. So, if we leave it alone to the discretion of the provinces, it may be to the detrimental interests of the country's growth. But then there were powerful voices heard from the state provinces or the states, and therefore, eventually that could not be accommodated so. Similarly, in the case of health and sanitation, these were the measures again proposed to be placed in the concurrent list, where the union could therefore have more powers, but eventually that also was subject to pressures by the states. So, we could see that within the Constituent Assembly, for economic reasons, fisheries, forests, etc., could be have been demanded by the states to be exclusively within their purview of lawmaking. Now, moving into the constitutional scheme which has been entered into in 1950, you could see that the distribution of legislative powers discussed in Article 246 form the crux of the discussion on the matter, because Article 246 distributes the legislative powers in between the center and the states in such a way that the federal status of the country could be kept intact. But in all situations, if one looks at the language of Article 246, it gives a primacy to the union or the parliament for that matter eventually. But all out you can see that the lists are enumerated. The items for legislation are enacted in the 3 lists which appear in the 7th schedule of the Constitution. List 1 stands for the matters on which the parliament would enact the laws. List 2 for the state to enact laws, and list 3 is the one which is called concurrent list, where both the union and the states have the power to enact laws. So, the source of power is derived from Article 246 in terms of making the law, but the items are enumerated in the 3 lists in the 7th schedule of the Constitution. So, accordingly, perusal of these entries in the list in the 7th schedule show that there are many items which have repercussions on conservation of environment and development also, but then it could be seen that it was not as seriously discussed as it is discussed in today's context. but the fact remains that many of the items which one can see in the 3 lists would have serious consequences for the environment regulation. Now, there are some situations envisaged in the constitution wherein even though the power of primacy is vested with the union and the state lists are exclusively reserved for the states, the union could enact laws on state list in exceptional circumstances. And one such article which is been used at times to conserve issues of environmental concern is the one referred to in article 252 of the constitution, wherein if 2 or more states make a request to that effect and the respective proposal is passed in their houses of the legislature, then the parliament could take the initiative of enacting the legislations. Now, after the 42nd amendment in 1976, we have added article 48A in the constitution in part 4 that deals with directive principles of state policy. Now, it therefore casts a duty on the state to preserve and protect the environment, forests, wildlife, etc. Similarly, a newly added provision in fundamental duties, article 51AG, also casts a similar obligation on the citizens in general and also on the state. Apart from all these provisions, one can see that under article 253 of the constitution, it is the parliament which has been given the power to enact laws in order to comply with the obligations undertaken by India under international law. So, one can see that even though the items may be falling within the state list, by the way the language is being used in article 253, the parliament is having the power to enact laws even on the state items if there is an international treaty governing the matter. Now, so generally if one looks at the Constitution of India, it can be seen that article 246 limits the legislative powers of the union and the states. Then there is a residuary power which in the Indian context is vested with the parliament under article 248. There are exceptional circumstances wherein this union could legislate even on the state list. An example of that is article 252. For complying with international obligations, article 253 vests the powers with the parliament. So, all in all, it shows that there are powers enumerated in the constitution which could be adequate enough to protect the environment of India in a sustainable way. Now, we then move to the second source, that is the legislations enacted by the states and the union. Now, for our purpose, we would focus only on the union laws. This is in no way diminishing or diluting the effect of the state legislatures in their effort to protect environment. There are many states which have enacted strong legislations for preservation and management of natural resources, having a deeper impact on environment. For our purpose, we look at a few legislations. So, the list is not an exhaustive one, it just introduces us to some of the legislations and their key features. So, for that purpose, I would be looking at the Wildlife Protection Act of 1972, the Water Act of 1974, the Air Act of 1981, the Environment Protection Act of 1986, the Biological Diversity Act of 2002 and the National Green Tribunal Act of 2010.